Karnataka High Court has recently wrapped a woman for her appeal for alimony of over rupees 6 lakhs per month. Justice Lalita Kaneganti refused to entertain the request, saying if she wants to spend, let her earn. Now, according to the petitioner, this amount was needed to fulfill basic needs such as bangles, chains, sandals, watches, etc. And part of the alimony demand, reports also said, included 4 to 5 lakh for medical bill, which included treatment for physiotherapy and knee pain that was attributed to the to the ex-husband. Now, and his negligence. The court, however, was unimpressed, and the judge said that she has no responsibility for any other family member or children. Questioning, does anyone spend this much in a month? The court, however, did not dismiss the demand for alimony and called on the woman to present a more reasonable account of expenses and not exploit the process of the law. And as you can imagine, this has led to a lot of reactions as well. First, let's listen in to what the judge said.
The petitioner wife shall file the actual required expenses. If they are the actual expenses filed, then the court will consider the same on the next date of hearing. Next para. Learned counsel appearing for the husband submits that an amount of rupees 63 lakhs. 63 lakhs is in circulation.
In the shares, ma'am.
As she is,
as per the bank statements.
As she is doing the share business, which is denied by the learned counsel appearing for the wife. The husband shall file all the documents on with an affidavit and serve the same on the counsel appearing for the wife, and the wife shall file an affidavit along with, in the said affidavit, she also disclose her expenses also.
My lord,
on that, orders will be passed.
All right, so that is, what the judge said on this exorbitant demand. And as you can imagine, this video went viral, lots of comments. But to talk more about this issue of alimony and, where the law stands in India, we're joined by Abha Singh, advocate in the Bombay High Court, and also Dr. Ranjana Kumari, women activist and chairperson, Women Park Connect. Thank you both for joining us. And Abha Singh, your comments first on this video that has gone viral with many, especially men commenting on what was viewed as very unreasonable demands, and what the judge said. The judge didn't throw it out and said, come back to me with something more reasonable.
There is a court order in Rajneesh versus Neha, which this learned judge also addressed to, and in most of the family court cases that we handle, Rajneesh versus Neha very clearly says that both the parties, be it the husband or the wife, they have to give their assets and liabilities statement. And on that basis, the court decides, and usually it is seen that Supreme Court has given 25% of the husband's earning to the wife or the children as maintenance, because this is clearly prescribed in section 24 of the Hindu Marriage Act, which clearly says that if the divorce proceedings are on, so maintenance, pendant, light and expense of the proceedings. So that is what the section says, that if the divorce proceedings are on and the wife or anyone, it doesn't say wife, it says either of the party, if they do not have sufficient resources to maintain themselves and pay their legal fees, then the other party is supposed to give them maintenance. And under this section of 24 of the Hindu Marriage Act, these people had come to the court and asking for 6 lakhs. In fact, there have been times where family courts have given interim maintenance of 3 lakhs, 2 lakhs. This is usually done because there are other court orders which say as per the lifestyle which the wife is used to. Because if you see the case, the wife's lawyer was saying that he is using brands and this, that. But yes, the judge was also right in her place to say that you come with a realistic amount, because the children's fees and expenses is already being taken care by the husband, and 6 lakhs is on the higher side. Nonetheless, if the wife can justify that the husband's earnings are, say, 20 lakhs, 30 lakhs a month, and she is not earning, Because there have been cases where if the wife's earning is more than the husband, recently Bombay High Court ordered that the wife should pay 30,000 maintenance to the husband as long as the proceedings are going on. So the crux is, as per Rajneesh versus Neha, they both should present their assets and liabilities means your expenses and outgoings. And on that basis, and that is why the learned judge did not reject the case and said you come with more realistic figures, and 6 lakhs is on the higher side, and which is so because the husband is already taking care of the child expenses, etc.
That's right. And, the 5 lakhs required for physiotherapy, 4 to 5 lakhs. But at the same time, Abha Singh, you're saying that if the husband's earning 30 lakhs, if there was a certain lifestyle, it wouldn't be unreasonable if they could justify it. Dr. Ranjana Kumari, now this is obviously this one-off case and it's become a talking point, especially since the comments by the judge saying that if, you want so much, why don't you earn it yourself? And also asking if this is reasonable for a single person. But let's face it that more often than not, women find it a huge struggle to even get that basic alimony.
Yes, I mean, always it is, and especially if women is asking for a divorce, then certainly she is on the wrong side. She must have done something which is not acceptable in the family to husband. So all the blame goes on the woman. At the same time, her expenses, there was a judgment, as Abha was quoting, where they said that decent expense. Now, decent expense has to be decided. The earlier, do you know what was the alimony earlier under the Hindu Marriage Act? It was 500 rupees. And then, of course, it was increased to 2,500. This lady has already got 50,000 from the lower court as maintenance. But if, whole life she has been with the husband, she is not making any money, she's not going to go for any job, and she used to a particular kind of life, then that needs to be assessed by the court. And they cannot just, and also at some point of time, I've been also sent all these tweets and trolls. I think they're all very happy. Mostly men are very happy that, oh, look, these women are asking for unreasonable 6 lakhs. You never know. Maybe her knees have to be replaced. Maybe she needs a bigger treatment. Maybe she has, women work, back-breaking work in the house to maintain husband, children, household. And if they fall sick, then they need to be taken care of, unless, of course, she has insured herself. So I think it's really, I feel that a little bit overstatement has come. Honorable Judge has to see what was her expenses and how much the income the man is making. So this is only interim arrangement. Otherwise, what normally should happen is they split the property in half and half. She's a newly married, legally married woman, and she deserves half of his property. That's what should be. Globally, that has been an acceptable arrangement. That, and then let her live on that, because if you keep women at home, don't allow them to do any work, or they're not building any capability to look after themselves and children, then what do you expect at the time of divorce? So I think it's really little bit, we have to think through. And 6 lakhs, of course, looks very big. But there are people, if you open all kinds of branded clothes shops and malls and all that, and women are getting used to all that as much as men.
Especially if she was used to it during the course of her, her marriage, and if the husband can afford it. We're also joined by Mrinalini Deshmukh, senior matrimonial lawyer. Ma'am, and your comments on this. And yes, Dr. Ranjana Kumari, what you said about the judge's remarks, which became very catchy, is wants to spend, let her earn. But was this lady earning all this while? Was she stay at home? It's not easy. I mean, all of us are working women, but we know that for those who haven't worked, it's not easy to suddenly get into that workforce. But yes, Mrinalini Deshmukh, your comments on this particular case.
Good evening. Thank you for having me over. I think it's a very interesting and a very debatable issue which has come up. These are the remarks of the court in the course of the arguments probably that were going on for the maintenance part of it. I think we should not only go by the observations or the quotes of the judge, because it may have been said in a particular context. Now, I do these cases practically every day. So I know there are certain judges who make certain comments, and the judgment also does not necessarily reflect all the comments that have been made by the judges during the course of the argument. It is a reaction that the courts have to give, because somebody says I want 7 lakhs and the courts are and the judges are going to think that, listen, I don't even get more than 1 lakh per month as my salary, and why did this woman want 7 lakhs? So this is a mindset, sometimes it's there, or it comes from a position that whether every woman should be claiming and show that sense of entitlement. When you decide cases of maintenance, alimony, etc., especially, I think what the courts do and need to do as a lawyer, having practiced in this over 2 decades, I would say, is to remove the wheat from the chaff. Because I believe that not every woman who comes is a destitute, who's asking for alimony, and not every man who comes is a perpetrator denying, and vice versa also. So in genuine cases, we do need to give a very sympathetic approach towards the woman, because she needs to stabilize herself. She needs to stand on her feet. And lastly, and more importantly, it's like a start of a new life. What the courts probably meant was that today, question, okay, this is not my remark, otherwise I may be misquoted. Question, are the women misusing the laws? Are the women demanding and using the legal process to have kind of a legal extortion, not in maintenance, but sometimes by filing false criminal cases, etc.? Are we going towards a society where maybe 5% or 10% of the women are misusing the provisions of law, and the 80% who are genuine cases are suffering? So these are all the questions which are socio-legal questions that the courts and all of us here need to understand. So it is not appropriate to say that, okay, you must think in favor of the woman, or you should. It's not correct to say that, okay, the man has to pay. It doesn't work this way. It has to be done in a manner which is appropriate and looking into the circumstances. What I feel as a lawyer, because I appear both for women and for men, so I may be able to give you a little, how do I say, a little balanced view, is genuine cases the courts do consider. But today, some of the courts, and especially the trial courts, I would say, because they have all the facts, circumstances, they are fact-finding courts, they all know that in these cases, sometimes there is misuse of law. So this could be one of the cases. This is not the law of the land. At the same time, the tenets of jurisprudence for maintenance is the income of the husband, the income of the wife, the lifestyle led by them as husband and wife, the number of years invested in the marriage, the dependents, if any, and so on and so forth. So it is not one single factor that the courts take. One last thing. The Supreme Court of India in the year 2020, October, headed by Justice Indu Malhotra, has laid down the parameters as to what are the disclosures of the income to be done in a famous case of Neha versus Rajneesh. Now, that has become the guidelines for all the maintenance cases, whether it's 125 CRPC, domestic violence, Section 24 Hindu Marriage Act, etc., etc. Both the parties are supposed to disclose their income, their bank statements, their ITRs, and other related financial documents if there is any issue of maintenance. This is bringing about transparency. This is bringing about some amount of transparency as far as the facts of the case of the funds are concerned. So I think we should not be passing judgments over why the judge said such a thing, but we must also be aware that the fact that a lady judge has made such a statement in the open court, that means there has to be something very major for her, with the facts which came before her, for her to make such an observation, that too against a lady who was a claimant of maintenance under the Hindu Maintenance Act.
Right. Let me just get a quick comment. I'm out of time, but Abha Singh, your comment on this, and yes, this video has been eye-catching, and the judges' comments, as you said, have been very something that have been remarked upon. But yes, Abha Singh, your final comments on this.
When we talk of equality and equal protection of laws, on one hand, when we are talking of equality, transparency is a must. But since the laws are very clear that the wife, if she is unable to maintain herself, then maintenance should be given to her. And this was but yes, If it is on the higher side and she cannot prove it, if 5 lakh are the expenses, but if it is a one-time expenditure, then the judge is not going to give her for every month. So that she will calculate, and accordingly, that is why assets and liabilities, your 3 years income tax returns are now seen by the courts, because there has been a misuse of law to some extent, but still that fact cannot be taken to deny women their right to maintenance, and if they're not working.
Right,
but if they're working,
absolutely, and we know more often than not it's a big struggle. In the cities it's different, and in other parts of India it's different. So yes, while this particular case has been eye-catching because of the what is viewed as exorbitant amounts in the comments by the judge, but yes, this is a very a delicate issue as well, and an important issue. Thank you so much, Abha Singh and Mrinalini Deshmukh, for joining us.